Elizabeth, welcome to the show. Welcome back to the show, actually.
All right, I was going to have been here before.
Absolutely.
Thank you very much for having me here.
I mean, this month we are bringing up the Sexual Assault Awareness Month, and quite an important month to also just bring some education. Let's talk a bit about sexual assault within Uganda.
Yeah.
What is happening on the ground right now? What are the statistics? What are we seeing that is happening within the police, within communities, and so on?
Yeah, so this is very interesting to have this conversation right now because the police crimes report is not even, I think, a month old or so. And this is basically the report that looks at the trends of crime and the numbers to really study and analyze what the Uganda police is doing as per their mandate, but also really just to let the public know what's happening. And the last report sort of shows you trends from what was happening around post-COVID and then right now. And we make boast of a decrease in the number of cases, right? The recent report shows, a stark difference from 14,000 something in 2021, 2022 to now 12,000. And that's about 2,000 less, which I think is not a call for celebration because we still have 12,000 people that are reporting. And I must remind us that when you hear 12,000, it's not just the whole country, number, right? Yeah. Those are just the 12,000 that made it to a police post somewhere and recorded this case altogether. And out of those 12,000, we are seeing about 55,000 that made it to court. And why am I mentioning this? Because a lot of sexual assault are criminal offenses, which means that they are tried by court for someone to get a punishment for whatever it is that they've done wrong. So the process of which cases make it to court is an important one for us to look at. And the fact that we have 12,000 cases and at the end of that year we only have around 5,000 that have made it through the system, even when there's been an increase from the years before, is still something we need to worry about. And the number is something for us we need to also, of course, reflect on. I just also wanted to say there's been also an increase though, even when broadly there's a decrease in number of offenses, crimes reported. We are seeing an increase in the number of defilement cases, and that's very worrisome because these are children. The offenses against children are very worrisome because we are meant to protect these people and they depend on us for care and for guidance. But if we still have 10,000 defilement cases that actually made it to the police force, because we know there are those that never make it, there are those that pay their way out, there are those that negotiate SGBV cases. Just last week, the team from NEBI was telling us they had to go through the police to request for a memo to be issued at different police posts, just reinforcing the fact that negotiation is not acceptable in cases involving sexual offenses, especially of children, but of boys and women generally also. So this shows you that we still have a long way to go. The cases are still many. Those that make it to police are many. There are those that just never make it. There are those that get negotiated, like I just said. So the state is still worrisome, of course, because we are dealing with this problem amidst very, very limited resources for both the police and the judiciary that plays a core role in ensuring that there is solutions for the victims.
A lack of resources almost sounds like an excuse if you're talking to the family of the victims, if you're talking to a victim themselves. What do gender-based violence victims and sexual assault victims actually go through? What are the challenges they go through within the legal system? Once they go in and report, what are the stories? Why is it that you're talking about only 5 cases that reach the highest level where they could actually get some justice? What are the victims actually going through?
It's a very tough journey for a victim of sexual violence in this country. And I'd like to paint you a picture, right? First is that when the incident happens, there's already a problem that sometimes people do not know the safe 2-hour rule. People do not know that you should rush to the nearest health center to get the quickest assistance. We've had clients that quickly run when this happens. They come to FIDA. That there's that information gap on what you're meant to do immediately to make sure that you secure the evidence that is primary in this whole process. So many times there's usually a difficulty in just getting people to report. When this incident happens, yes, there's usually issues of mob violence, mob justice towards the perpetrator because that's how the communities feel at that point. But many times the reporting doesn't even happen. So then there's that missed gap. The fact that the person may go to the police station and they are not able to get. Then the second challenge that we usually see around that makes the victim's journey more difficult is corruption. Sometimes when victims go to the police force, they are told they are supposed to fill that police form 3A, which really shows the nature of violation and the extent, but also the evidence that is very helpful in prosecuting this matter. We have had so many times across all the districts where we work, clients complain that they are asked for money between 25,000 and 30,000. Now, for a family that sometimes does not feed, for a family that is unable to take kids to school, 30,000 is a lot of money for a Ugandan family that is already experiencing this challenge that we are talking about. Many clients go back home to look for the money and never return. They shower that child and they get into negotiation with the family of the man. Now, that's the second journey. Now, the other part of the journey is between this statement being taken, between the re-traumatization of the client and the parent, if it's a child, or the woman or the boy, depending on who it is during this process. The police, the CFPU especially unit, that's the Child, Family and Protection Unit, has been financed to the extent that some of those have reduced. But quite honestly, there is a lot more we need to do. With the whole taking down the statement, with having that file sanctioned, there's usually times when clients tell you, you know, they told us they will call us, and it's been months. So we do not know if this file will be called. And we have cases that get lost in transition. You know, when state attorneys do not, you know, proceed with these files to where they are supposed to go, then you never get justice. Now, in there, get into this matter that I painted for you, and there are cases from so many years back. Currently, we have an issue of case backlog. The witnesses of the matter, the clients, they get derailed. You know, it doesn't feel like they are getting assistance if I have to sit for years before I ever see any headway be made on my matter. That even when the judiciary is trying, and this is not to say that there's not been initiatives. We have seen initiatives like the SGBV special sessions that are, like the name, they're really special sessions that are set aside each quarter in each district, and they handle SGBV cases to try to fast track them out of the system. But in there, you will see the challenge that the witnesses are already out of the picture. Sometimes if it's a child that is about 15, the child is now an adult. Depending on where they're coming from, they have married or married another person, married into another home, and they no longer want to hear the fact that they were assaulted. But all this has an effect on how she feels treated, on her dignity, on re-traumatization a little later in life. And then there comes the problem of, again, corruption. Sometimes those that pay their way out, the system delaying, the fact that even when you want your client to win this matter, the prosecution has very little to work with to prove beyond reasonable doubt that this harm was had. So because of that lineup, that series of challenges in there, it makes it very difficult for clients to actually access
it
justice.
does sound very hard and very difficult. I can't even imagine. But there seems to also be a bit of a gap here if we're going to talk about families in particular. So if you're saying to me that families are part of negotiations with the perpetrators of family to hide this and sweep this under the rug, and what happens afterwards? What is supposed to be done? Is it an education issue? Is it an awareness issue? Why do families prefer to sort it out within their safety of their own home, if I should even say, rather than having to approach the courts?
It's so interesting, but I think I'll respond to that in threefold. One, it's culture. We've been to communities in Karamoja region, in northern Uganda, Arua, Nebi, Pakwach, Zombo, Madiokolo side, where it's sort of part of their cultural practice that they negotiate when an elder, especially a man, either who is a leader of a clan or is a leader in the family, just always a man. That's the privilege that men get to, especially an elderly man, that they prefer to negotiate between families so that the social fabric is not broken, so that the family does not break away, so that we do not expose some of the negative things happening in our family, so that we do not blow out of proportion what is happening in the families. But unfortunately, this is not about usually, the negotiations were usually, promoted even by FIDA ourselves, because we know part of also legal aid is negotiation so that families, are living in better ways. They are able to solve their problems themselves. Local solutions for local problems. However, we encourage this in issues like theft of cows. The children are fetching from this borehole, yet they should fetch from another. That's why we can negotiate. But sexual violence cases, totally unacceptable under the law. And yet, they still do it. They sit to negotiate because like I mentioned, most of the abusers of these children are perpetrators that are known to their families. And then secondly, there's an issue of poverty. Yeah, when someone comes up with 2 million to hand over to a family that has not touched 100,000, whose children are not in school because they cannot afford 1,000 every single day to transport their kid to school, even when it's UPE, then 2 million shillings is a lot of money. We shall quickly leave your feeder officers and tell you we'll return, and we'll never return. The police tells them to go home and return the next day, and they never return because they've been paid money. So because of that underlying issue of poverty, it leaves families very vulnerable to being abused, to being negotiated out of what they would have preferred to have done at the police. But then also something else is that there's also an information gap. We need to educate people that you do not shower after you have been assaulted. Make sure you visit the police station immediately. But there's lots of stereotypes. You know, that girl will not get married if she does not shower immediately. She may never get a partner, a man. She may never enjoy sex. There's all these stereotypes. You hear in community dialogues of people tell you why they may quickly rush instead of running to the police station, and make it very difficult. But also very importantly is that a lot of people have actually lost hope in the system because they know that someone goes and reports and they are released almost immediately. Right, their constitutional rights of bond and bail. However, there are certain cases where it's in the interest of the family that this person is kept away from the family, because it also has a message it's sending. But when the system, for instance, right now we've seen issues of prerogative of mercy, where I think it was a list in 2002 or 2023 where there were 11 people that benefited, and 8 of them were perpetrators of sexual violence. It was defilement. And what message are we sending to perpetrators out there? You know, when a case gets reported and it's 3 years later and the witnesses have never been called, what message are we sending? When a police officer asks that you fuel them to be able to go to arrest a perpetrator of sexual violence, these are not serious messages to show how serious the problem is that we are dealing with. So families, because they do not see that agency from the systems meant to help, they'll also relegate that to one of their small issues, discussing which well we shall use, whether women could sit on this council or not, or whether we could give some money to this family. So because of those issues, you find that reporting becomes a problem. And that's why even when the police crimes report shows us a decrease in the number of cases, we must be worried because there's so many cases that just never make it to the police.
From reporting to justice, where are the gaps? We'll be right back. What more actually needs to take place or needs to be done to make sure that this problem is solved, especially when it comes to receiving justice? What needs to actually be done is what needs to be put in place?
I really think Uganda has reached a point where we must put our money where our mouths are as a country. We must invest more. If you look at our budget, it's the season, right? And you people in the media, I know, are following these things. How much are we investing in some of these things? How much are we investing in the judiciary? In areas of Zombo that I talked about before, we are seeing one magisterial court serving over 5 districts. It means for someone to leave Pakwach to go to Zombo to have their case heard or wherever else, they'll need 2 days to travel on the bus to arrive. We do not have state-led or state-funded shelters, so they'll go to a shelter if they are lucky, then wait for the case the next day. If you're lucky and the judicial officer appears on time and you're able to travel back home, those are about 3 days.
My goodness.
So it, excuse me, it becomes very difficult for someone to be able to get justice if that is the situation. So we must invest in having more courts doing this work. We must invest in taking courts to communities and not the performative community mobile courts. We are talking about issues where actually judicial officers go to the communities and have mobile courts to show communities what they're doing, because it's important that communities trust the system to give them the justice. And only that will happen if we are investing in the CFPU office, we are investing in the judiciary to be able to do their work. And then something else is, I think we also need to do a lot more in terms of awareness. The government needs to invest more. If it is through the parish model that they're now frontlining, if it is through schools, we need more. A lot of sexual violence is happening in schools. Teachers, heads of schools are marrying girls in Form 4 VAC. Where did he meet this girl? He was her former teacher. So why is that even a normal story being run on a regular wedding show? A former student is marrying a head teacher, a girl that's about 17 or 18.
Celebrated love. It's
you know, it's a very worrisome place we are in. We need to do more awareness. And then we need to pay attention to the newer forms of violence also, that I know right now we are not paying a lot of attention to, and that's the technology-facilitated violence. There's lots of men that are speaking to your children through YouTube, through WhatsApp, through these apps online that you give your phones to. There is a lot of things that technology is assisting with right now, but we need to watch what our children are watching. There's people exchanging, telling kids. I saw, you know, a video on TikTok of a parent who was talking about a man who asked their child to take pictures of their breasts and send to him.
It's horrible.
And it's so interesting that this is happening on your parents because you don't have time. I'm back in the evening. These days, you know, homework is sent through a WhatsApp group for the parents. You receive the WhatsApp work and then you do, and then that's it. A lot of this violence stems from online. A lot of people that stalk women, that stalk children, begin with the online, as posting pictures of our children online, their schools, their name, their location, on which time you're picking your kid, your father exposing your child. So we need to pay attention to that. Then, lastly but not in any way least, we are living in a country without a national legal aid bill, which means not everyone has a right to a lawyer. You're only entitled to a lawyer when you've committed a capital offense like murder, like rape, like defilement. I know many Ugandans don't like to hear that defilers or rapists have lawyers, but you are entitled to a lawyer in case it's a capital offense of that nature. But if it is not, for you, a regular Ugandan, you're going to need to hire a lawyer. Lawyers are extremely expensive in this country. Many people cannot afford, even the professionals in the offices that we usually look at, can't afford many of the lawyers in this country. So many of the people that I'm talking about relegate their services are relegated to institutions like FIDA, legal aid clinics like us. We survive on development partners, donations, grants, and many of us are not yet at the stage where we can operate independently. It means when a project 3 years ends in Zombo, the cases that the FIDA lawyers have been handling, what happens to them? We offer our services free of charge, but it's because there is someone that's financing us to be able to do that. And that's not a good place to be, because the most vulnerable sometimes does not get, because we are not everywhere. We are currently in only about 25 districts out of so many in Uganda. So what happens? So we need the government to fast track that bill, as well as Uganda has done when it comes to the legal framework. We need the National Legal Aid Bill as soon as possible. It's also important that the Sexual Offences Bill, this is an opportunity. It's a new parliament. It's been shelved. It's one of those that we could use to make sure that punishment of perpetrators and sending a very, very strong message to them is something that is a priority to this country.
I think at the end of the day, when there are no consequences, I think we end up having the same behavior on and on again, the same behavior being repeated on and on again. When is a case, when is it too late, I guess, or for a case to be solved when it comes to sexual assault? When is the time where it's like, it's over for this case, it's just not going to happen?
Yeah, it's really never over for clients, because we've seen clients, cases that happened about 10 years ago when they were still young, and then the case is being heard with them even now as adults, perhaps with children and etc. So a case may not be able to be too late to handle. However, it's going to become a little more difficult, a lot more difficult for you to secure a success, for as long as, you know, if evidence is not kept in a proper manner. Just last week, the cyber crimes office from the police was reporting that a lot of evidence of cyber-related technology-facilitated violence is very difficult to prosecute, because they still have difficulty in even storing the evidence. In the fact that, for instance, in a case of a physical violence, fact that someone did not get a police form 3, and they have to corroborate their evidence so that you can prove beyond reasonable doubt that that particular offense happened. So it becomes a little more difficult. So you can corroborate your evidence, but it's never too late to
I'm pretty sure there's some people who are watching who've had the same experience, perhaps maybe when they were younger, and now that they're older and more resilient and maybe have a little more awareness and knowledge, what are the chances of them actually securing a trial of some sort, or actually taking their matter back to the courts?
It is extremely possible, only that I must warn, and this is not the doing of the NGOs that are doing this work like FIDA. Because of the case backlog, you may not get your case heard as soon as possible, right? But it will indeed get registered as a matter eventually. You will experience a lot of difficulty throughout that journey because you have to get all this evidence up and the delay in your case getting a hearing, but it will get hard.
And finally, what would you like to say to families and to friends, sisters, brothers? Unfortunately, in our community, we all know somebody who's either been sexually assaulted, but not enough of us know sexual assaulters. We don't know the abusers. Not enough of us know abusers. And those who do know are quiet. What would you like to say in terms of the people, the community, and how we need to deal with this?
This is a very interesting question because many times we pay attention, especially as lawyers, to what the government is meant to put in place to make sure that things move smoothly for remedy to be a lived reality for many survivors and victims. However, families, communities are living what they are meant to do to protect their children. It's not your primary role to make sure that your child is not assaulted, but it's your primary role to take care of them. I know because we are poor, many of us work in the informal sector, a parent that leaves home at 4:30 a.m. to make sure they get their kid to school and get to the market to get their stock set up in the stall till evening may not be able to be a present parent as much as me who wakes up and I drive myself to office and then I leave office at about 5 and go home, pick my kids, spend time with my child. It may not be the same, but that's the majority of Ugandans, unfortunately, so that's what we are working within. So we need families, one, we need communities to believe victims. Many times, many of you, when children come to you reporting, you are more concerned about the reputations of the perpetrators than the children and the women and the boys that report. That's, you start dressing and undressing this client, even when someone comes out on social media, they're asking you what you are wearing, where you are going, who were you with, were you in a car?
Why did you go?
Why did you go? Why did you in fact get born? This is all together after your report. So we need families and communities to believe clients. Secondly, we need communities to support victims. Many times when these things happen, communities you're hiding because it's your husbands, it's your stepbrothers, it's the boy that paid school fees for your last born, it's women in communities that are raping these boys. But because you know them, you hide until it comes to your backyard. So for as long as you keep hiding, even if the government hires as many lawyers as possible for you, even if the National Legal Aid Bill is passed, even if there are many judicial officers to handle these cases, we are wasting time. And then thirdly, please, there is so much information out there. I know we cannot change what the people have interest in. There are so many programs like of this nature. NBS runs so many programs across the different stations that they have. But what is our interest? What are we checking for on TikTok? What are we checking for on social media? What are we recording for our children? There is just so much relegation of work that communities and families, and both men and women, need to do to ensure that protection is a reality for girls and women and children generally in communities. So for as long as we don't do that, it doesn't matter how much the government does, we are not going to make any headway.
Elizabeth, thank you. From the law to lived reality, does justice follow through? Stay with us. Welcome back. For many survivors, the journey begins with speaking up.
On a scale of 1 to 10, I would rate the strength of our laws at 7 out of 10. The other 3 out of 10 or 30%, if we are to speak in terms of percentages, is attributable to, and this with regard to protection, speaking to protection in the process of seeking justice for victims of sexual violence. The first one is we have challenges with our witness protection. The Witness Protection Bill is one of those bills that has actually failed at Parliament, and it actually sought to offer protection to victims of sexual violence as well, because one of the challenges, again, that they experience is social cultural attitudes towards the handling of sexual violence cases, or the reporting and prosecution of sexual violence cases within the court system. In a number of districts where we operate, you have cultures where they tell you that reporting a sexual violence case or reporting a case that involves violence with a family member will actually lead to your family getting cast in the future. And that is a custom within the community, which actually hinders victims from reporting cases of sexual violence to the police, and therefore they are not prosecuted. So you have victims ending up withdrawing their complaints and not going to court to give evidence because they have experienced intimidation from family members and from members within their community. So I feel like one of the things that would kind of close that gap would have been a witness protection law, which we do not have in place. Another gap that I see is a gap that pertains to out-of-court settlements or resolving sexual violence cases out of court. One of our policies at FIDA Uganda is that we do not handle cases that involve mediating matters involving sexual violence out of court. We believe that sexual violence is a very serious crime against women, and so it must be prosecuted to the full extent of the law. But our law does not have any prohibitive clauses when it comes to out-of-court settlements in sexual violence cases. So you find that in most of the sexual violence cases that occur in this country, a number of them, especially those that involve minors, a number of them are settled out of court once the perpetrator offers to compensate the parents of the victim so that, you know, they can withdraw the complaint and not pursue it any further. There are jurisdictions like South Africa where they have very strict prohibitions against settling sexual violence matters out of the court system. So it would help a great deal in enhancing access to justice for victims of sexual violence if we adopted similar provisions within our law. Of course, what makes that an even more complex challenge is that there are instances where you will actually find victims saying that they don't want to have the perpetrator arrested and prosecuted because he got me pregnant, I now have a child. How is he going to provide for the child when he's in prison? So again, poverty is another layer that makes the whole process of getting or securing access to justice for victims even much more complicated, especially in a lot of the districts outside of Kampala and Greater Kampala. Those are some of the very common challenges and scenarios that we encounter when we are trying to give support to victims of sexual violence. Another aspect within our laws that I believe can help to enhance access to justice and protections for victims of sexual violence is one that speaks to minimum sentencing. So in certain countries, for example, Kenya actually has a Sexual Offences Act, which provides a minimum sentence. Minimum sentence means that in any specific sexual offense, once the accused person is found guilty, the judicial officer cannot give a sentence that is less than the one that has been prescribed in the law. And so, of course, we have had instances where that has they've tried to challenge that in Kenya, but I think they were not successful. But it's something that I think can also be adopted for Uganda, because again, in our line of work, there have been instances where, due to, especially in districts outside of Kampala and Greater Kampala, where a judicial officer has issued a sentence of a fine of 3 million for an offense of defilement. So how is society going to understand or be deterred in terms of committing the offense of defilement, or condoning or trying to harbor a person who has committed the offense of defilement, trying to shield them from being taken through the entire court process? Because you see, part of the objectives of criminal law is to actually deter the commission of offenses. So how is that deterrent if you're giving a sentence of a fine of 3 million for an offense of defilement? So it speaks to also what the legal safeguards are, even at the point of sentencing perpetrators once they have been convicted of sexual violence offenses. For Uganda, I would say that the conviction rates are very low. If we look at our annual crime report of 2025, I think, which was just recently released, you'll see that over 79,000 sexual violence cases were reported, but only about 29,000 convictions were secured, with most of the cases still pending. A lot of that is caused by, again, the lengthy court processes, where you will usually go to court and they will tell you that the prosecution has not yet, investigations are not yet complete. Yeah, so that oftentimes causes a lot of delays, and that is why you see that we have a lot of pending cases that are still pending before the courts, vis-a-vis the number of convictions that have been secured. Also, I would like to highlight that oftentimes when investigations have not been concluded, when trial of a case begins, and the case has been coming up for hearing on several occasions without the prosecution actually having completed investigations, within our laws, the accused actually has a right to ask court to dismiss the case for want of prosecution. So that also, the delays in the investigations and the gathering of evidence also contributes greatly to the failure of handling cases to their logical conclusion within the justice system. Some of them, in certain instances, have been adopted in some areas. For instance, the aspect of counseling for victims at the different stages, and this is counseling within the structures of the justice system as opposed to counseling outside of the justice system. It makes it more sustainable when it is happening within the justice system itself, where we have very strong referral pathways amongst different state actors, between police, for instance, and the district health officials, in terms of offering not just physical support in terms of medical treatment or physical medical treatment, but also psychosocial support in terms of counseling for victims. Also, in certain instances, especially those involving minors, courts do actually hold closed sessions to enable the victims ably and comfortably express themselves when they are giving their evidence or testimony, and that helps with making the evidence strong for securing a conviction. There are instances where victims have not showed up because they were not guaranteed of privacy during the process of the hearing or the process of them giving their testimony. So adopting that as a common standard, but also communicating that to the victim as a best practice would, I believe, go a long way in terms of it being survivor-centered, but also actually ensuring that the cases are handled to their logical conclusion and justice is actually secured for the victim.
Sexual and gender-based violence is not just a legal issue, it is a societal one. From reporting and medical response to investigation, prosecution, and community support, every step matters, because justice is not only about law in place, it's about whether they work for the people who need them the most. I'm Victoria Sibatani, and this is Impact Uganda.